This program is brought to you by the Reeves Law Firm, www.reevesfirm.com.
In the know.
Good evening, everyone.
In the know. Tony Reeves, fire. Following the news in any way, shape, or form. No shortage of things to talk about. What does it mean? What will it bring? Is this a reality we simply have to accept? Tony Reeves, fire. Tony Reeves.
Let's go ahead and get started.
For those who have had the opportunity to follow the videos that I've been doing for a while, this will constitute the second part of my what happens after the hearing discussion. So I hope this information is useful to you. So sit back, relax, and prepare to take some notes. Now this may sound kind of silly, but the first question I would have to ask is, did you have a representative with you at the hearing? If you did, ask your representative what else needs to happen. What usually happens at the hearings is when the hearings are done, you're so fired up because if the judge asked questions or you heard the vocational expert or there were things said that made you mad, you're angrier about what may have happened at the hearing as opposed to focusing on, okay, let's go forward. So first thing you need to ask is, what else needs to happen? Meaning, is there any additional medical records that they need? Is there anything that needs to be clarified? Anything like that. Also, ask your representative what problem areas that need to be addressed. If your representative has a reason to believe that there may have been some portions of your file that might have been troubling or even troubling to the judge, ask so that you know what you need to do to start focusing on correcting those things. And most importantly, don't get mad. I know that's a stretch because you've been waiting for years. You finally go before someone and you feel like this is my one shot, and now the hearing didn't go the way you expected and you are hot. You're entitled to have your moment. Go have it. And then after that, start focusing on fixing any problems that may have been brought to your attention at that hearing. That's the joy of having a representative, because they can tell you about those things and at least bring those things to your attention so you can now focus on correcting any problems. If you went to the hearing by yourself, you do have some options after the hearing. First and foremost, you can decide to maybe get an additional representative. And that's going to depend on how you felt the hearing went. Now, I know this is going to sound weird and you've probably heard this before, but clean up any medical conflicts in your records. Well, what is a conflict? A conflict is that if you've got two things saying two completely opposite responses to each other. Like somebody says the sky is blue and somebody says the sky is green. Somebody says it's day, somebody says it's night. If there are conflicts in there, make sure you do what you can to clean them up. Well, why is this important? Well, the court has a duty to address these conflicts. So if you've got one doctor saying one thing and another doctor saying another that's completely in opposite of each other, the court has to resolve those conflicts, meaning looking at the file as a whole, they have to determine whether the medical evidence and additional evidence maybe supports one opinion greater than another opinion. They have to make a determination of whether or not the doctor's records vibe with each other with regards to some information, and then address how the evidence may support a determination by one doctor as opposed to the other. If you leave it to the court to address the conflicts and figure out what is what, you may not like the outcome. I always tell people is that you bear the burden of proving you're disabled. If you leave it to the government to figure it out, you might not like the outcome. Therefore, if you are trying to do what you can to support your case, you want to take a proactive role of getting as much information so that you can help paint a picture that makes it easier for them to make a determination in your favor. If they have to figure it out, you're trusting that they're going to see things the way you do. They may not see things the way you do. So, what are the two areas that you typically will see? Conflicting doctor statements. That's where one doctor says one thing and another doctor addressing the same issue says something totally different. So, So how do you deal with that? Well, what you can ask for is provide all the records from both doctors to one of your two doctors, preferably the one who's a specialist and preferably the one who sees you the most and has the most intimate knowledge of your condition. And ask one of your doctors to review both statements and the records and to clarify. That means you've got one doctor who can look here. Like let's say you have a doctor, you're on diabetes, and you've got a primary doctor that says your diabetes is not that bad, but then you have an endocrinologist who is a specialist in this area that says your diabetes is really bad. Well, if you've gone to both of them the same length of time, go to the endocrinologist, take them all the records and say, well, my doctor over here is saying this. How do you resolve these differences? And it's not a personality conflict contest. What the doctor should do is review the medical evidence and make a determination where that doctor says, well, this medical evidence supports my assertion. I do understand why that doctor says this, but this is why this medical evidence is stronger. Now, same thing with internal conflicts. Internal conflicts is where your doctor says something, but the medical evidence and the notes they provide says something completely different. What does that mean? Well, let's say that your doctor says that you can't stand very long, you can't sit very long, you can't walk very long, but then when you look in the notes themselves don't really paint the picture of somebody who has that many limitations. So what you need the doctor to do is to basically go forth and explain how is it that they say that you have what we call benign examination results, or that your exam results are not that bad, yet they believe that you can't walk, sit, stand. Ask the doctor to clarify and specify what exactly are they relying upon to render this opinion despite the information that they have that says to the contrary. These things are conflicts, issues that you want to address, so this way the court is not trying to piecemeal together certain pieces of information, or more importantly, discounting information. Like in the internal conflicts, your doctor may write a statement that's great for you, but the judge may look and say, you know what, because the notes in the examination says one thing and the statement says something else, I'm going to lean more to what the notes say and less in terms of what the limitations are. Now, also address any problem issues. Problem issues can be broken down into two categories. There's both non-medical issues and then there's medical issues. Non-medical issues are things like your taxes or earnings, where you say you became disabled after a particular date, but then there's earnings on your records. You want to be able to address those things, get copies of those records if those records aren't available. Medical issues are drugs and alcohol, smoking, non-compliance. And I want everybody to know, this is not a list of everything, everybody, so don't think, oh, these are the only things that come up. Weird things can pop up too. Unemployment, long-term disability, workers' comp, whatever the case may be. When these particular issues come up, you have to ask the court, what do you need from me in order to address these things? Well, if it's non-medical, you may need to get copies of the records. Like, for instance, if there's a question regarding your taxes, if there's a question regarding your earnings and there's nothing in the record to support it, get them copies of these records. If there's if you were working, let's say you were working and it looks like you made a lot of money, but you weren't really doing anything because your friend who you were working for, your cousin, is paying you on the books so that you get a paycheck, but you're not doing anything. Well, you're going to need a statement from them. Okay, things like that. How do you address the medical portion? Ask a doctor to write a statement about the issues. Do these issues impact your limitations? So most people don't know that under the regulations there is a specific regulation that deals with drugs and alcohol. So if Social Security believes that drugs and alcohol have an impact on your ability to do things, in other words, be found disabled, they're going to want to know, if they remove those things, are you going to improve well enough to go back to work? So you want a doctor to be able to address those issues. And also, same thing with smoking. If you've got breathing problems and you're smoking, you want a doctor to be able to say, if the person is no longer smoking, it's not going to make a difference because the breathing is still bad. You're not telling them to say this. You want them to give their opinion about whether it is. Non-compliance. Are you following the doctor's treatment regimen? And if you are, but they're putting non-compliance, ask them to explain, what do they mean by non-compliance? Are they saying non-compliance because you're choosing not to follow their advice, or because you don't have any insurance or you don't have money for the medication? Address these things so that you can be able to account for these things if these things come up after the fact. Okay? I cannot even begin to stress this enough. Make sure your file is up to date. When you leave that court, anything that comes up that relates to your medical condition, you have an ongoing duty to provide Social Security that information. Don't hesitate. Don't pause. Don't think about it. Get it and provide it. Social Security is probably, not, especially at the hearing level, they're probably not going to get it for you if you don't tell them about it. So what you want to do is provide any additional testing information. If you went through your CD and you noticed there was some records missing, get those records. If you know you have future appointments coming up, get those records once you go to those appointments. And most importantly, if you are having problems getting your records from your providers, don't wait and sit on it. Write a letter to Social Security. Tell them what efforts that you've made to get these records. Ask specifically for the court's assistance. So you want to make sure you say, hey, at the hearing, I told you I had these records. I went to the doctor on this date, this date, this date. They would not provide me those records. I don't have the ability to pay for them. I need you to subpoena these records, or would you please request them for me? Make sure you show them the effort that you made to try to get them if you do it on your own. And this is probably my biggest one. Don't lock yourself into the judge's timeline. Let me tell you what I mean by this. I cannot tell you how many times the judges will sit there and say, well, we should be able to get you a decision out in the next 30 to 45 days. And I tell my clients every time, do not lock yourself into that date, because there's a lot of moving parts to get your decision written. The judge may take about 30 to 45 days to make the decision, but then the judge's decision, he or she makes their recommendation in terms of their decision. They put it into a virtual folder, or queue as we like to call it, where a decision writer, which is an attorney that's assigned responsibilities for writing the decision, will pull it out based on first come, first serve basis. Then they'll write the decision. That, depending on how big that decision, it will determine how long it takes. Depending on how many decisions that person has to write, will determine how long it takes. Do not lock yourself into that date and that time, because you will stress yourself out if after the 45 days that the judge has told you this, you're thinking, well, it's been more than 45 days, they're going to deny me. And I keep jumping up and down saying, do not lock yourself. They're giving you an approximation, not an exact date. So don't stress over it. You're going to, but don't stress over it. What you need to be doing is keep updating your file. Keep focusing on addressing your issues. Okay? Don't focus on the exact date. Start working on getting that information that they need. And the most important things, if I haven't made it very clear throughout today's presentation, is keep updating your file. All right? If you have any other questions, please, as always, I welcome them. I look forward to seeing you here again. Again, my name is Anthony Reeves. This is your Q&A, Social Security Disability Today.